withdrew his previously entered plea of not guilty and pled guilty to count 1, burglary, a felony of the 2nd degree. The court referred the defendant for a pre-sentence report, victim impact statement, and psychological evaluation. Those reports have been completed and the state is prepared to proceed with sentencing.
All right, before we get to the sentencing, Mr. McDuffie has filed or sent several letters, the last of which was filed with the clerk of courts, in effect asking to withdraw his plea. Ms. Smith, are you aware of that?
Your Honor, since coming into the courtroom, I did have opportunity to confirm that with Mr. Duffy. His motion to withdraw his plea is based on ineffective assistance of counsel, and he did indicate that he still would like to be heard on that motion.
Okay, Mr. McDuffie, you want to withdraw your plea, is that correct?
Yes.
What do you want to say about that in support of that motion?
Well, I hear about this case to be dismissed due to the facts I, Carl McDuffie, was misled and was promised that I'll be doing probation time towards an F2 burglary. And not knowing about the case and the counsel, never read the discovery, always felt rushed and never understood nor have any F1 through F5 upon me of any state. I'm asking for time to be served for 146 days as being credited. I have not taken my mental health medication, so I have not understood the plea deal of an F2, which is now I understand that is due to 2 to 8 years mandatory prison time. And I was promised probation, which the F5 was thrown out, and for me to accept burglary for theft, which I've never intended to take, steal, or rob anyone or anything. But I did yell through a window, and I was going through a breaking and entry that was in the daylight, and through the law of 1092 federal laws of 28 USC section 191.5 US 47 1961 revised code of a 4734.99 penalty misdemeanor in the 4th degree and 2937.011 in the mental health code. I am not a violent human, Your Honor. And
You're not a what?
I'm not a violent human.
Violent?
No, I'm not violent, no. And I never intended to do anything to harm anyone in this situation. I felt like the person that it was done to was more so of a parent to me than a victim.
Who?
Miss Sharp.
And when's the last time you saw? Well, all right, what else you want to say on the motion to withdraw?
I just never got the discovery to understand. All I was told was there was a 6'1" black male walking down the street with a bag or something like that. I'm not 6'1", so that's all I wanted to say about that.
Ms. Smith, anything you'd like to add?
Your Honor, I'd only like to make the court aware that Mr. McDuffie and I did speak following his change of plea. It was the first time that he indicated a concern about not receiving his own copy of discovery. I, as counsel, was in receipt of discovery and did review the discovery in this case with him.
Okay. Ms. Alessi, anything you'd like to say?
Yes, Your Honor. I know this court is required to conduct a hearing in regards to the defendant's request. Looking at the case law, I think there's a 4-part test that this court should consider that was set out in, I believe it was a few cases, Garcia, Taylor, Peterson. The first part of the test is the court should consider where the accused was highly represented, is represented by highly competent counsel. Here at the change of plea, the defendant was represented by counsel. The second part of that is where he was afforded a full hearing pursuant to Criminal Rule 11. Before he entered that plea, there was a lengthy colloquy back and forth with the defendant prior to entering that plea, advising of his rights, the rights he was giving up, and the possible penalties associated with the offense. The defendant acknowledged he understood those rights. He signed a written plea of guilty, and the court accepted that plea at that time. The third part of that test is the court should give an impartial hearing on that motion and then consider that request. But there's also case law that it's well settled that a change of heart regarding a decision to enter a plea is insufficient to serve as a basis for withdrawing one's plea. There's several 11th District cases that cite to that. It's unclear what discovery was reviewed with the defendant prior to entering that plea. But if his decision today just amounts to a change of heart regarding that decision for fear of the consequences here, the state would be opposed to that motion to withdraw his plea.
Okay.
Your Honor, if I may, before deciding the motion, I would ask the court to inquire of the defendant whether his statement that he was promised probation in this matter, if he was indicating whether or not he was that promise was made by his attorney.
I was just about to ask that question.
Thank you.
Okay. So I have some questions for Mr. McDuffie. You indicated one of the, as Ms. Smith just said, one of the primary issues is that you were promised probation. Is that correct?
Correct.
Okay.
Correct, Your Honor.
Who were you promised probation by?
By my counsel here,
Okay.
Rachel Smith.
All right. When we went through the change of plea hearing on June 18th, I spent probably about, my recollection is around 20 minutes going through the various questions. And one of the first things I told you is that I was going to ask you a series of questions to make sure you understood the rights that you had, the rights you were given up, and whether you were waiving those rights. And I told you if you had any questions of me to stop me and ask me. And there were a couple occasions where you did ask me questions, is what I recall during the course of that hearing. I also told you that if you had any questions for Ms. Smith to stop me and I would give you time to talk to her. And you acknowledged both of those things. Do you recall that?
No, I don't.
Okay. So then we went through your rights, your constitutional rights. One by one, I asked you if you understood the rights and asked you if you were waiving those rights. And throughout that hearing, you indicated to each and every question I asked you that you understood the right and that you were waiving that right. Do you recall that?
I recall that, yes.
Okay. And you did, as I said, you did ask some questions, and the questions were answered, and we continued on with the hearing. Now, when we got toward the end of that hearing, after we went through the penalties, potential maximum penalties, the potential of probation, and what would happen if you violated probation. And you acknowledged that you understood those penalties. And then
I said what I said, but I wasn't really fully understanding what you were saying to me when it was said.
Okay.
That's all.
I go through these hearings, these change of plea hearings, probably a dozen or more times a month. And when I ask the questions, I listen to the answers, and I look at the individual I'm talking to. And if I'm not satisfied that they don't understand, then I don't continue. If they give an answer that they do understand, but they don't want to waive the right, then I don't continue. If a recitation of the facts occurs, as happened in this case by Ms. Alessi, the next question I ask of counsel is whether they have anything to add to the facts. And then once that's resolved, then the next question I ask you, and what I asked you, is whether you agreed with those facts. And if you say no, then I don't continue, and we just go along with the trial date. If you say yes, and I'm satisfied that you agree and that you acknowledge that you did what was represented by the recitation of facts, then I accept the plea.
All right.
Now, one of the other things I do after that is I ask you if anybody, if you believe that because you're entering a plea, if that would cause me to automatically be lenient on you. Okay. One of the things I ask you next is whether anybody promised you what I would sentence you to in this case. And when I asked you that question, you said no. After that, because if you had said yes, then we would have had another discussion. Okay.
Right. That's why I didn't understand. I didn't understand that.
And then the next question I ask is, do you understand that at the time of sentencing, I do not have to accept the recommendation made by either the prosecutor or by your lawyer? And you said yes. Okay. Then I don't have, and I asked you if you understood, I don't have to accept those recommendations.
Understandable.
Okay. And we went through the entire hearing, and you acknowledged all your rights. You indicated a waiver of those rights. You understood the recitation of facts, agreed with the recitation of facts. And that the sentencing was completely up to me. It's not up to them. They can say whatever they want in support or in support of whatever they want, but I don't have to listen to anything they say. I listen to it, and I consider it, but I do what I think is the correct thing to do. Okay? And you acknowledged all that. Okay? And your main concern today seems to be that Ms. Smith promised you would be on probation, and that you didn't receive and didn't discuss with her all the discovery. Now, Ms. Smith has been a lawyer for a period of time, and she's been in this court over the past year multiple times, and just finished a trial yesterday after a couple of days. Okay? And in my view, she's a very good, very competent, very thorough lawyer. And so when you say that she didn't share this information with you, that's contrary to everything I've seen with her. Okay? You're kind of intimating that for some reason she hid stuff from you in order to get you to plea. And that's not my experience with her, so I don't think that's a credible statement on your part. That's where I'm coming from, okay?
I understand.
All right, so it seems to me the reason that you don't want to do this, the reason that you want me to allow you to withdraw your plea is because you don't like the potential consequence facing you.
I don't mind. Whatever it is, Mr. O'Donnell, whatever I feel like to be deserved, but I just know, and my truth is, I never intended anything to harm or anything to take. It was not my intention. So from here on out, like I agree to whatever it is she wants to come with as far as what she's told me. I agree with what she says. I'm not scared of whatever it is you want to give to me. I'm just what I'm scared of is being out of my children's life. That's what I'm scared of, to be honest with you.
Okay. All right. So based on everything we've discussed, I'm going to deny your motion. We'll proceed with the sentencing. Ms. Smith?
Thank you, Your Honor. On behalf of Mr. McDuffie, we are asking the court to consider a period of community control in this matter. Begin this offense, which Mr. McDuffie has pled guilty to, occurred in the year of 2023. Mr. McDuffie's statement that he did not intend to cause harm to anybody through his conduct today is consistent with what he has relayed to counsel throughout the pendency of this proceeding, and I hold a good faith belief that it is consistent with his conduct leading up till his arrest. Your Honor, Mr. McDuffie has admitted to conduct that amounts to the offense of burglary. He did, I don't want to misstate the time period, but shortly after the date of this alleged offense, Your Honor, Mr. McDuffie himself reached out to Wickliffe Police. He indicated that he indicated that he had broken into a home, that he did something that he shouldn't have, that he was remorseful for it, and he then left police a second phone call that day. Mr. McDuffie then went back to Wisconsin, which also has ties to his childhood as well as the home that he has admitted to burglarizing. While in Wisconsin, Mr. McDuffie admitted himself into a mental health facility. Law enforcement at that time did call that mental health facility and confirm his location. They also spoke at length with his mother, who confirmed his mental health issues and his location as well. Mr. McDuffie came to be in the custody of the Lake County Jail because upon his return from Wisconsin, albeit several years later, he did turn himself in. He has submitted himself to prosecution on this matter from the very beginning. Mr. McDuffie has acknowledged with the court that he has mental health disturbances, as well as the fact that at the time of the alleged offense, he was using ecstasy on a daily basis. He was high. He did not understand what he was doing. And now that he does understand what he did, he is remorseful for his conduct. He has repeatedly indicated his remorse for the victim without the opportunity to offer it directly to the victim in this case. And as such, Your Honor, we would ask the court to impose a period of community control.
All right, Mr. McDuffie, what do you want to tell me before I impose sentence?
Like I said, the victim herself, her father was like my only father growing up, from him giving me everything, for me being in the situation that I was in a situation where I did lose a lot of everything, and I was in a situation where I was going to go over there just to cut her lawn, and I thought that possibly that she was not alive anymore because her lawn was from zero to treetop, and it kind of disturbed me because I didn't know if that was the end of her life because of the lawn, the way it looked. And I know Mr. Sharp kept his lawn clearly clean from day one, so it was just into me that I wanted to, if she would have answered the door, I would have asked to cut the grass. And that's all that would have happened. I would have not be going through this situation at all.
Why did you go over to that house in the first place then?
To go over there to see if Miss Sharp was alive, because the grass was zero to treetop.
All right, but why were you on East 296 then?
Because I'm from East 296th Street, sir.
Okay. Well, where did you live at the time?
I was in Wisconsin. I don't know, I was at my mom's house at 100.
In Euclid, right?
Yes.
Okay, so what led you to walk over to East 296?
I have friends that also live on East 296, from the Argensingers to
Who?
the Argensinger, John Argensinger, and Jones, Gregory Jones as well, was another friends of mine. And I have also the Beasleys, which I know them as well, growing up.
When is the last time you'd been over to the Sharp house?
That day that it
Before
happened.
that?
Before that?
Yeah.
I can't recall. That I don't know. I don't know when the last time I've been over there. I can't.
Was it more than a year?
I've been through there because we have family reunions at that park down the street. So I don't know how long ago.
Which park?
Civic Park, which is called Love Lane, or Civic Park to me, but I don't know what they call it anymore. I know Civic Park, we have, every year there's a family reunion there. I have a lot of family here in Painesville, Ohio as well. But we have a family reunion there at that park every year.
So why specifically did you go to East 296 that day?
I can't recall. I don't know. I just seen her. I don't know. I have friends on that block, in that area. So basically.
So am I to assume that you were there to see friends and not Sharp?
But I seen how her yard looked, and it was
I know you saw, but you didn't see how you didn't know anything about a yard until you were already on 296, right?
Right.
Okay. So when you saw the yard with the high grass, and you remember that Mr. Sharp always kept his grass nice.
Correct.
What did you do?
I had a thought. I don't know. I think I was high, so I think I just went over there and knocked on the door, and then I went in there and I rang the doorbell. I think the next day I went over there and I yelled through the window. It might have been the next day. I don't know if it was that day I actually did it, but the next day I went over there and yelled through the window, and nobody answered the door. When I knocked this time and I yelled through the window, so it wasn't once, it was twice I went over there.
Okay. So how'd you get in the house?
The back window.
Why did you go in somebody's house in the back window?
I don't know. I thought.
What did you do once you got in the house?
I can't recall.
Well, you took a bunch of stuff. You took a whole bunch, the place was disturbed, and you took a whole bunch of stuff,
I just took a
put it in
bag.
a bag, and left.
I just took a bag. I just thought it was like a baseball, football, baseballs. But I don't know what was in there. I don't know.
Why did you think there were football and baseball cards in there?
I don't know why I had that thought. I honestly don't know what that was about, because when I had
Were you high that day too?
Yes. And when I got a notification that the police were looking for me, I threw the bag in the trash at a flower
The
shop.
same day?
Yes, at a flower shop.
Why did you throw it in the trash?
Because I never wanted to intend to take nothing. That wasn't my intention. Like I said,
What was in the bag?
I honestly can't remember. I honestly don't remember. All I remember is like some change. That's all I remember was some change.
Well, there was like $300 and some worth of change that was missing.
I don't know. That was how much it was.
Well, I'm telling you what it was.
That was not my intention.
Well,
Take nothing from her.
but you did. I mean, the bag was in the house, right?
Right.
And you put stuff in the bag, or you at least took the bag. You intended to take the bag, right?
No, I didn't intend
You
to
did.
take it.
Then why did you take it?
I can't recall why. I don't know where my mental was at the time.
Well, you were higher than a kite, right?
Pretty much, sir. Yes, Your Honor.
So there was a wedding ring that was taken,
No,
an engagement ring,
no.
a wireless speaker,
I didn't have none of that.
a wallet,
No.
a money jar with $350 in it,
No, I don't remember that.
some other things.
Ring? No, I don't remember none of that. I promise you that. I'm not gonna lie about it. If I had something to do with that, I would tell you.
Well,
I'll tell you.
Ms. Sharp is indicating there was, the best she could figure, was at $4,158 value of items were taken.
No, I never.
Yeah, that's what she's saying.
Well, I never seen that. I didn't see that.
Well, you just told me you didn't know it was in the bag, you just threw it in the trash.
Yeah, so if that's what she indicated, then that's not what my intention was, never to take $1 from her at all. I didn't know that.
What was, you keep talking about your intention. What was your intention when you
To
went
cut
in
her
the back
grass.
window?
If she would have answered the door, it would have been all about cutting
Okay.
her grass. That's all it would have been.
What was your intention? Because the window was only open about this much with a screen on it. You removed the screen, put it on the ground, opened up the window and got in the window. What was your intention going in there?
I think it was just to make sure she was okay. Is there somebody that was in there?
If that were the case, why didn't you, when she didn't answer the door and didn't respond to your yelling, why didn't you call the police and say, you got to check on her because I think something may be wrong?
2 years ago, I don't know, sir.
You were higher than a kite, right?
Pretty much, yes.
Okay, that's the problem. Okay, problem is that you've been using the ecstasy every day. Were high, went to a house where you didn't belong, and then opened up a window when you couldn't get in the door and stole a bunch of stuff. That's the problem. And it's very dangerous when people break into other people's houses. Bad things happen.
I just thought she was unoccupied. Like, I just didn't think that
Well,
was there.
what does it matter whether it's unoccupied or occupied? You just told me you went there and went in through the window because you thought something was wrong with her. Now you're
Right.
telling me you thought it was unoccupied?
I did. I thought something was wrong. I thought she might have been, deceased. That was not the intention.
You can talk about the intention all you want to talk about, but I can infer what the intention is from how you did what you did and what happened after you did, and the fact that you didn't intend to take anything and the police contacted you, the first thing you did, you tell me, is throw this stuff in a dumpster. Right?
I did.
So, anything else you want to say?
I just apologize for my actions. That's all.
All right, Ms. Alessi.
Thank you, Your Honor. In this case, the defendant invaded the sanctity of the victim's home at a time when she was likely to be present. At this time frame, she was working from home. She was always home. It just so happened on this day she had gone to a high school reunion, a party, and was not there, thankfully, at the time that the defendant committed this offense, but she could have been. And to be clear, the victim did not know the defendant. She doesn't recall ever meeting him or seeing him. She doesn't deny that he may have known her father, but according to the victim, her father had passed in 1997. So certainly the defendant hadn't seen him any time in a long while, giving him any reason to believe that he may live there. And then, after committing this offense, the defendant flees to Wisconsin, and the victim has to live for almost 2 years, knowing that the perpetrator of this crime is still out there. And he knew the police were looking for him because he talked to the police, and he admitted to committing these crimes. On top of that, the defendant took irreplaceable items from the victim's home. He took her mother's wedding ring, engagement ring, things that cannot be replaced. Money just can't simply buy new ones. Those are things the victim will never get back. In addition to the other items in the bag, there had been some checks and a debit card that were taken. And after this offense, that information must have come into the hands of other people, because then the victim was continued to be victimized because there was charges on those cards for over $3,000. Someone had got a hotel and ordered a bunch of stuff online.
Where was that?
Where did that occur?
Yeah. Where did the use of the card occur?
The use on the card, the A Loft Hotel was rented in downtown Cleveland.
Okay.
And there was a lot of stuff ordered online. A police report was made to the Wycliffe Police Department. They were unable to identify a suspect in those crimes, or at least make an arrest. I'd submit to the court the defendant's not remorseful. His recitation of the facts that I think this court has already picked up on is not believable and is illogical. He didn't come to the victim's home with a lawnmower. He climbed in the back window believing someone was hurt instead of simply calling 911 or knocking on the door. And then once inside, seeing it's fully furnished, he didn't immediately leave. He took things. The defendant has a lengthy criminal history, including 6 convictions as a juvenile, several convictions as an adult, including multiple probation violations resulting. He had 2 separate prison terms.
No, I don't.
Most recently, he was released November of 22, and even now he has an outstanding warrant of Milwaukee County in Wisconsin for a theft offense. So the state is asking prison. Prison is appropriate here given the defendant's conduct in this case and the defendant's criminal history. As of today, he has 118 days of credit.
Okay, I think I've got one from the PSR. It looks to me like one prison sentence that when you mentioned when he got out in November of 22. Is there something I'm
Well,
missing?
when I'm looking at it, it appears in the 2019 case for bail jumping felony. He received 18 months prison, and then in 21 out of Racine County, I see another 18-month state prison.
No.
And then I believe in the summary, even from probation, it even has he has previously been sentenced to prison 2 times.
Okay, I see it now.
No.
I see it now.
Those are not facts.
All right. I have reviewed the pre-sentence report and the psychological evaluation as well as the victim impact statement. I've considered what Mr. McDuffie has had to say, what counsel has had to say. I have considered all the provisions of 29, 29, 11, 12, and 13. There is a presumption that a prison sentence should be imposed in this case. And as outlined in the pre-sentence report, there's a long